Yeah, good evening, all of you. I'm Dr. Srinivasan. Today's program of this presentation by one of our interns will be conducted by Yashodan Mirwankar. So I request Yashodan to take over from here onwards. Yashodan?
Thank you, sir.
Yeah.
Good evening, ladies and gentlemen. I am Yashodhan Mirvankar, an intern with the DRAS Praghna Research Writing Program. It is with great enthusiasm that I welcome you all to this research paper presentation event. I would like to extend a warm welcome to our distinguished mentors, Dr. Srinivasan sir, Commander Dr. Ashok Dua sir, Group Captain Parthasarthi sir, and Commander J.K. Nair sir. Sir, your presence here signifies a commitment to the pursuit of knowledge and the advancement of a collective understanding. This evening, we have a presentation of the research paper on government surveillance against the right to privacy in matters of cyberspace in India by Arghish Akolkar. Before I invite him, let me familiarize you with the program. We will commence with an introductory address by Dr. Srinivasan sir, followed by the presentation by Arghish. After the presentation, we will have a short question and answer session on the topic, which will be followed by our mentors sharing their perspective on the topic concerned. I now invite Dr. Srinivasan sir to deliver the introductory note. On to you, sir.
Thank you, Yashodan. Once again, good evening to all seniors and, of course, our dear interns. The purpose of having this presentation, let me start with that first. The purpose of having this presentation is of the belief by all of us mentors here that good research, well-researched thoughts must also be presented. A researcher must develop the confidence to present his thoughts and even defend them if there are questions. The purpose of doing so is very obvious. Two things become very clear as the objectives. The first is the confidence that the researcher has gained through meticulous work that gets showcased. The second is the deliberation, the presentation and the question and answers both also work as a medium for spreading that knowledge. It invokes interest in others to catch up on that particular subject, and if they are not already familiar with that subject, to get to know. Because today we are aware that all knowledge, any discipline in the world, all of them are interconnected. Now coming to the topic under presentation today. In short, we are going to hear our Arghish talking about his in short, we are going to hear our Arghish talking about the right to privacy, the government's authority or the permissible levels of authority, I'll put it that way, the government's permissible levels of authority to mount surveillance on your privacy, on that right to privacy, or infringe that right to privacy related to the concept of what we call as human rights. We don't need any expert talk or extraordinary knowledge to understand that in millions of ways today, human beings, these 8 billion people on this earth, are more connected courtesy your social media, courtesy your internet, courtesy your every other. Once upon a time when Grupi Partha sir and me and Dua sir and J.K. Nair, when we all grew up, the means of communication were limited to radio, or if you're lucky, you will get a long distance STD call once in a blue moon. Okay. Otherwise, only telepathy. You just keep talking through your mind on it. Our means to access the world or even to listen to the thoughts of the world were so much limited. Today, you, all of you youngsters, You're all 21st century kids. You don't actually, I won't be surprised if any of you tells me that, sir, what is radio? Because we don't need it. Because today communication has become so, and this has actually empowered people, but we are also aware that that empowerment to communicate has also resulted in the same tools of communication being used for, shall we say, wrongful purposes. And those wrongful purposes could sometimes cause detrimental effects on the society. It could challenge the governance. It could even challenge the entire international community. Therefore, governments today are more concerned about how to control the negative use. And in their enthusiasm to control that negative use of these tools of communication, some governments do go a little too far, and some governments couldn't care less. We have all kinds of formats. So the topic that he is going to talk today is not just about one law student presenting his research on the right to privacy, the concept of human rights, and the government ability to control it, or some legislations. No, it's about you and me. People who are non-legal professionals, okay, who are just citizens of this world. This topic is so much relevant to all of us that it is important for us to understand and appreciate. When we say the freedom of expression, we must also ask how free should that expression be, because of this network of communications and the challenges that it poses on, shall I say, the negative side. So this topic is of tremendous importance and relevance and should be of interest to all of us. And therefore, I am delighted to say that our intern Arghish Akolkar has spent nearly 4 months to dig into various dimensions of this thing, policies, acts, court cases, and he has constructed a very thorough and a well-argued paper, which looks at, as I said, right to privacy and the government's ability to control, or the amount of ability that we should grant a government to control. Obviously, this will always remain a hotly debated topic because the means of communications are going. Now, we have got AI also to add to this. Okay, so it will only become more complex. Therefore, a scholarly understanding as well as a citizen understanding this topic is of importance to all of us. So saying, I thank Yashodhan for asking me to give this introductory note. And now, Yashodhan, you can please proceed with the program.
Thank you, sir. I now invite Arghish to give his presentation on the topic. Over to you, Arghish.
Thank you, Yashodhan, for the kind introduction and the sir for the kind words. I'll upload my PPT. Is it visible, sir?
Yeah, it's coming up now. Yes, you're on.
So the topic is, as it has been previously mentioned, it is government surveillance against the right to privacy in matters of cyberspace in India. The research questions with which I went ahead with the research paper is, number one, what is the status of right to privacy under the Indian Constitution? How has it evolved? And what are the various restrictions on it? Number two, what is the legislative requirement for the state to conduct surveillance? What are the various legislations and rules that allow for surveillance in the cyberspace domain? How pervasive is the power of cyberspace surveillance in India in the context of the right to privacy in India? Number four, how does the right to privacy guaranteed in India fare up against the powers of surveillance that the government enjoys? And number five, what is the net nature of the surveillance state after taking into consideration the three-tier test described in the Puttu-Swamy judgment in cyberspace? So before I go ahead with the explaining the flow chart, I would like to just explain the meaning of cyberspace. So in context with the research paper, I have taken the definition of cyberspace as it has been defined under the Oxford Dictionary, as anything which includes communication. For example, it would include telecom services and internet, TSPs and ISPs, telecom service providers, and internet service. So going ahead with that, I would like to explain with the help of this flowchart about what is the nature of surveillance in India. When it comes to the surveillance powers in India, there are two things from which surveillance powers emerges, which are the legislations and agreements. So legislation, I think everyone is aware about the nature of legislations. For example, we have the Telegraph Act, we have the CRPC, we have the Evidence Act, and other legislations which are present. The interesting thing is the agreements part as well. So the relationship between legislation and agreements is very much like the relationship between Yamunotri and Yamuna itself. So if the agreements never existed, there would be no legislation. Similarly, as Yamunotri never existed, there would be no Yamuna. The agreements create condition for the certain service to be provided. And the interesting nature is the agreements have been made by the government in such a way that the power of surveillance of the government is inbuilt in the agreements itself, and legislations are just something which build up upon the surveillance clauses present in the agreement. So when it comes to the nature of surveillance, I have divided it into two parts. First is targeted surveillance, and next is mass surveillance. So targeted surveillance refers to when the government seeks to do surveillance on a specific person that I have defined as targeted surveillance, and mass surveillance is people in general, everyone in general. It may be social media, it may be ISP, it may be metadata and other things. So after the powers of surveillance arise, we have the legislative restrictions which are placed. Many of the, especially for example, we have the Telegraph Act. Telegraph Act has a telegraph rules of 1951, which presents certain restrictions. For example, a committee has to be set up after the surveillance has been done, and various things on the grounds on which the surveillance can be conducted. I will go into detail about it later on. And the next are the judicial restrictions. And after judicial restrictions are also overcome, then we have what we consider as legal surveillance in the court of law, especially. So you can consider as a legislative restriction, the judicial restrictions are the reason why we enjoy the a bit amount of privacy that we have today in the domain of cyberspace. So when it comes to the nature of targeted surveillance, as I've defined previously, we can club the powers which arise from the various legislations into the following parts. Number one is seizure of devices. Number two, interception and detention of information. Number three is the compulsory submission of information from electronic devices. Number four is the compulsory decryption of information. Number five is a clampdown on end-to-end encryption. And number six is the power of the government to make rules on anything related to devices. So the interesting thing is, many people, for example, whenever I have discussed this with anyone, people always assume I don't think there is anything draconian with the sixth power, which is the power of the government to make any rules on anything related to devices. But it would be a bit short-sighted to consider this, because only because of this section which is present under the IT Act, the government is able to come up with these rules, IT rules, which, for example, we had in 2021. There was a big hullabaloo about the OTT rules which came about. But the interesting thing which people missed is in the IT rules of 2021 was that government made it compulsory for the intermediaries on social media to send, number one, who sent the message. Number two, if a message has been forwarded, who was the main forwarder and who did it get, who received the message. Like in WhatsApp, you see the forwarded message. That was a result because of the government legislation on it, and the WhatsApp adhering to the government legislation. The government can track you down. This might seem good in a way, in the best case scenario, but in the worst case scenario, it can be weaponized in a way to crack down on freedom of speech as well. Then the next is the compulsory decryption of information. So under the IT rules, government allows for encryption to happen to up to 40 bits itself, which today is done up to 144. That is the level which has been allowed, but 40 bits is the norm. So as per Ria Pefkaran, she had just commented on this, interestingly, in one of her writings. She is considered to be one of the juggernauts in the field of encryption. She had commented that 40 bits was enough. 40 bits level of encryption could be any person with a computer which can work for 3 to 4 days could have broken through it in 2004 itself when the IT Act was brought. So, but yet today we have 40 bits of encryption. And the next is the government under IT rules again, as I mentioned, which emerges from point 6. has said that all the powers which have been, that all the intermediaries or data fiduciaries have to create a decryption key which is available for the government, so that government can access decrypted information as well. And the next is compulsory submission and confiscation of information from electronic devices. So there are various, for example, CRPC has these legislations, the IT Act has this legislation, DDP, the Digital Data Protection Act, also has these legislations. The different is, for example, all levels of government under can enjoy this power. And the best thing is your consent is not required at all. I'll explain it to it in the next as well. Then we have the interception and detention of information. I think, as the name suggests, the government can intercept any information and detain any information. One of the interesting things about the way the legislations when it comes to surveillance has been created is that all these powers are complementary to each other. For example, without a clampdown on end-to-end encryption and without a compulsory decryption of information, the government cannot do interception in the first place. All of these are important to one another, and they play about very equally, and they intermingle very perfectly. The question obviously after arises that, okay, the government has powers, but which agencies of the government? It would be, as I mentioned, all the government bodies which are allowed. It would be suffice to say, especially under telegraph rules, that any local police person, for example, if they get the permission of the Directorate General of Police, can get access to it. The interesting thing is, at times, the police, at the said court or the said police, can do the surveillance and then get the permission as well for the act to be done. It's a very interesting way it has been created. I will explain to it later on the legislative restrictions. So these are the nature of powers which are enjoyed. For example, the seizure of devices arises from Section 5.1 of Telegraph Act. So the question which many people might have is, why do we have to consider the Telegraph Act out of everything? The interesting history of the Telegraph Act is, Telegraph Act was made by the British to do surveillance on its imperial subjects to prevent freedom struggle from happening. But yet we still have it today. But it's like, as the name suggests, Telegraph Act would only apply to telegraphs. No. So Section 4 of the Telegraph Act has been defined in such a way that it will include any device which can be used for communication. Anything and everything which can be used for surveillance, which can be used for communication method, can and is subject to the Telegraph Act. There has been a bill which has been presented in front of the Lok Sabha to replace the Telegraph Act, but this Section 5.1 provision is retained along with the definition itself. The next is, as I previously explained, interception and detention of information, the compulsory submission of information. So, as I mentioned, one of the interesting things about the agreements is that, for example, all the TSPs, there are three kinds of agreements. TSPs, subjects are TSPs, ISPs, and the agreements are UAS, ULS, and other things. All of the agreements have a provision which says that the service provider, which is the licensee, has to come what may, set up a LIM system which is given by the government at their own cost. They have to maintain it at their own cost. The LIM here refers to the lawful interception and monitoring systems which has been present. And at the end, for example, especially for internet service providers, under the agreement itself, all the ISPs are mandated to go to have all the metadata linked with the MPLS, which is then linked to the government body, which is CMS. There is a central monitoring scheme, and all metadata has to go to CMS come what may under the agreement. And yeah, that's the nature of surveillance which arises from the agreements when it comes to targeted surveillance. An interesting provision of the DDP is when it comes to DDP, it is considered to be as one of the legislations which works on privacy. While the DDP Act does crack down on surveillance which is done by the corporates. For example, companies might do surveillance on, for example, the behavior of the customers and other things. The government has cracked down heavily on it in the DDP Act, but the government has also promoted its own powers. The most interesting thing when it comes to DDP Act is Section 36, which says that, this is the official verbatim, the state can require the board and data fiduciary to furnish any information as they may call for. Here, data fiduciary innately means that, for example, it may refer to social media companies, it might refer to Google, it may refer to anyone who has any form of data stored with them from the data principal. Data principal is an individual, The individual will feed data, which will go to the data fiduciary, who is legally bound to do proper storage and everything, proper storage and provide privacy and encryption and everything. But they can only protect it from other corporate surveillance, and they are not allowed to access that own information unless they have taken permission of data principal. But when it comes to the government, data principal is out of the scene, and data fiduciary has to submit the information come what. And then obviously we have the section 91 of CRPC, which is police or court can issue summons for production of information on purpose or purpose which they may deem fit. And we have other legislation which I have mentioned. For example, as I previously mentioned, the carte blanche which arises from section 69. From that, the rules arises from 6 of Information Technology Act. It makes a corporate body disclose sensitive information, data, or private information to the government. This perfectly works with the DDP Act itself, and these all aid and abet each other and compound the nature of power of surveillance which the government has. Then we again have this Rule 3 and 5 of 2009, which is said to that the competent authorities can intercept and monitor and decrypt information and so on and so forth. So this is the nature of targeted surveillance which is allowed. Every aspect of your cyberspace can be monitored under these. For example, if you have any devices, they can be seized. If you have any information, that can be taken over. That if you have any encrypted information which is going, that can be decrypted by the government. So the nature of surveillance when it comes to especially targeted surveillance is all pervasive. So I will be discussing the nature of legality also later on. So when it comes to understanding the mass surveillance in India, we have to understand that there are 6 current government schemes or programs, whatever you will call, or branches which are working on it. We have the LIMS. As I previously explained, LIMS innately refers to a system which has to be installed by every TSP, it is telephonic service provider, at all of their equipment. The government can access the LIM anytime they want, and the LIM has to be used by the government, has to be operated at the cost of the service provider itself. Then we have the crime and criminal tracking network system. As the name suggests, it innately refers to surveillance which happens in lateral surveillance, which is, for example, the public CCTV cameras and everything. And for example, at the end of the day, it might also refer to social media tracking. Then CMS come about when it comes to the ISPs, internet service providers. All internet service providers have to compulsorily set up an MPLS, which is a multi-portal linking setup, which will route all the metadata or the internet information which arises to the CMS, which is a government scheme where all the information gets collected when it comes to internet data, especially. And the next is Netra project. The Netra project basically means, for example, if you just go to Google and search how to make a bomb, technically this will, if you search that, you go into under the Netra scheme, you will go under the government watch list. And that is basically the crux of the Netra scheme. And when NatGrid, so NatGrid basically takes intelligence and surveillance information from all parts and just creates a certain database. It's like a library of information, or it's like more like an Amazon of information. All kinds of surveillance information that you want, that the government wants, it may be the central government apparatus or the state government apparatus or even the local police, they can get access to it through NatGrid. For example, I am right now in Pune. Pune's Maharashtra police can get access to what is happening in Chennai or which is happening in Delhi through the system of NatGrid. While certain frameworks to prevent that thing happening from NatGrid, but they are not public. And recently, in the 2023 budget, the government provided a massive funding for NatGrid project, especially. So that is also an interesting thing about the mass surveillance in India. And the next is Advanced Application for Social Media Analytics, or ASMA. This is a recent venture of the government, where, for example, and it's very similar to, for example, in Twitter and Instagram, you have the social media analytics which happens. That is very similar to what this thing does, but it is at a mass level. The government, for example, will check for, okay, there's a social media trend, who has liked it and everything. So the nature of mass surveillance is of 2 types, we can say. Number 1 is open source surveillance, and number 2 is metadata surveillance. And the power of the government to do metadata surveillance arises from the Unified Licensing Agreements, Unified Licensing Service Agreements, and under the Information Technology Act, Section 69B. So when it comes to the agreements, I have detailed about it later on. For example, system connected to the government has to be connected, as I previously mentioned. There and in case the CMS and in case there is an issue with the CAM, with the technology service provider and ISP, and the government is not able to use the LIM, which is a lawful interception system, the TSP can actually be fined for not allowing the government to do any kind of surveillance, and it also criminalizes or creates punitive measures in case there is a form of redundancy created. So that's an interesting thing, and obviously under mass surveillance, especially of this kind, under licensing agreements, whenever you get a network or internet service provider, you're anyway signing away your rights when it comes to this, especially. This is actually the interesting thing is this is actually one of the reasons why the government was against the Starlink program of Elon Musk from coming about. Even he would have to sign this agreement, and only they could do it. That is one of the interesting things, because obviously the licensing agreements which arise from two forms of information. Arise from things which arise they arise from the wires, the wires and cable form of communication. But when, for example, if satellite communication is used, which is which is strictly prohibited in India. For example, if you want to do satellite communication, then you will require the government permission. The government will do constant checks about what communication that you have done. You have to compulsory submit your satellite phone and satellite data. So satellite phones are restricted, and you have to only stick to cable as per the Indian law, because of so many restrictions on satellite law, satellite communication, and because cables are preferred by the government, because government can conduct mass surveillance and collection of metadata. So the next also thing is, it as usual arises from the previous carte blanche, which arises that the government can make any rules. So if any of you at any time visits a cyber cafe, this is an interesting provision which is present, that cyber cafes are mandated to save data for up to 1 year minimum under Rule 7. And if government asks for it, they have to submit it, or else they will be penalized. This is the nature of mass surveillance which happens in India. So the legislative restrictions of surveillance. This is where the privacy, this is where from where I'll start discussing the privacy aspect. We have the Telegraph Act, we have the Information Technology Act, we have the DDP, which is the Digital Data Protection Act. So I have also mentioned a very small comment that why shouldn't this be considered as an objective restriction against unchecked surveillance? That is actually for a very simple reason, because as per a 2013 RTI, back in 2013, where before the geo revolution and everything, the government was passing somewhere around 75,000 surveillance requests was being approved by a very underfunded and undermanned body, which is mandated to be created under Telegraph Act. The committee sits for 1 hour every 1 month, and they have passed 75,000 interception requests. That is back in 2013. So it would be suffice to say that due diligence is a bit questionable. And the nature, one more reason why legislative restrictions are very loose is because the government, for example, in the case of DDP, has created that the surveillance can be done by the government for functioning of the state. It has been defined in such a way, very loose-ended words have been used. For example, the grounds. For example, under the Telegraph Act, the government is allowed to do surveillance for suspicion of crime. For example, to prevent a certain crime from happening, the government can do such things. Nature of surveillance. So legislative restrictions are a bit questionable here when it comes to right to privacy. And the cream on top here is the structural operating procedure issued for lawful interception of communication. This happened in the backdrop of the Radia tape scandal, where the government, certain government officers and government department was conducting surveillance on a lobbyist and her actions. So the interesting thing is this SOP was created to promote privacy of the individual, and it was never made public to the people, that the people should not know about what are the privacy mechanisms which are present. And further on, I had previously mentioned about the body which is created under Telegraph Act. That body's reports are not to be made public under the grounds of national security. You can only know how many interception requests are sent, how many of them are approved. It's usually more than 90-95% they are approved. And Information Technology Act does not have that many restrictions on grounds of national security, functioning of state, sovereignty and integrity of the state, which over the years has not been clearly defined, providing a very good defense for the government to conduct surveillance. So the only the substantial way in which we can consider that there is right to privacy is from the judicial restrictions. Just a second. Yeah. So as I mentioned about the SOP, nature of the SOP as well. Then going ahead, I'll discuss the judicial restrictions which are placed on surveillance. So the question also arises that when it comes to judicial restrictions, what is the right to privacy? It has been a question which has pestered the government, pestered not even the government, the Republic of India since its inception and when the Constitution was written. So, for example, when the Constituent Assembly debates were happening, I have mentioned in detail in the research paper itself, there had been a lot of debates and deliberations about the right to privacy. Many, for example, Alladi Krishnaswamy Iyer, K. Hanumanthia, had argued about against the right to privacy being there in the context of the riots which were happening in Punjab and Bombay during that time. But interestingly enough, as right to property was included, Dr. B.R. Ambedkar had said that right to privacy will also happen because it arises from right to property itself. That is one of the ways in which the right to privacy is different in India for its origin than with other countries. For example, in UK, right to privacy came about in the judiciary from the Campbell judgment. In the Campbell judgment, the right to privacy, the court comes to the understanding of right to privacy from the concept of right to property. Even in the works of Locke, the famous social contract theorist who talks about life, liberty, and property, the understanding of property is such a way that it ensures privacy. But in India, the right to privacy emerges from Article 21, which is right to life and liberty, not property. So, under the Puttaswamy judgment, it has been defined in such a way that it arises from right to life and right to liberty, not anything else, not right to property, because right to property has been removed from a fundamental right to a constitutional right. Now, going ahead with the evolution, discussing the evolution, which I previously mentioned. In the starting itself, it was right to privacy was completely rejected. We had the MP Sharma versus Satish Chandra case. We had the Kharak Singh judgment. We had R.M. Malkani judgment. We had the Gobind Singh versus the state of MP. Until then, all kinds of illegal surveillances, which could be done by the government, bypassing Telegraph Act restrictions, were allowed in the court of law. Now, here I would like to introduce you to a legal doctrine, which is the fruit of the poison tree. This has been explicitly rejected by the court previously. The fruit of the poison tree is an American legal maxim or a legal doctrine which simply states that a case cannot be founded upon, case or prosecution against a person cannot be done when the action from which you prove that the person has done a crime or the prosecution is happening is based on an illegal evidence itself. AKA, if there is illegal evidence being presented, the case has to be dismissed. That was not the case in India. We had the Rajgopal judgment, which recognized the right to privacy, but not the meaning of the fruit of the poison tree. Then we had the PUCL judgment. The interesting thing about the PUCL judgment was it was the first time when the Supreme Court, Honorable Supreme Court, deliberated about the right to privacy. It criticized, it did not strictly criticize, it commented upon the nature of surveillance state which emerges from Telegraph Act and recommended the government to clamp down on the nature of surveillance which happens and go into legislative actions on right to privacy. But the government didn't do so. So the question about the Aadhaar came about in the Aadhaar card case. So Aadhaar card case or the Puttaswamy judgment as it is called today. So in the Puttaswamy judgment, the question was about Aadhaar and what is the nature of privacy and everything. That was the right to privacy was the primary question which arose in the said case. So under a beautiful judgment which was written by the Honorable Court, the Puttaswamy judgment is considered to be one of the best judgments written since the foundation of the Republic. There were 3 grounds which were established. These grounds actually originate from the modern college dentistry foundation dentistry case, which talked about restrictions on rights in general. And in this, the court came to the conclusion that there are few grounds on which the surveillance can be overcome, which is the first is the legitimate goal stage. Then the next is the effective means stage, which is there must not be any less restrictive but equally effective alternative. and the measures must not be disproportionate impact on the right holder. So, while the Honorable Supreme Court was deliberating on the measures, it provided a detailed understanding of what is legitimate goal stage and what is the alternative mean stage, but not about the disproportionate impact. I think in this, the Honorable Court wanted it to be looked into one case by case matter. And we have actually seen since the Puttaswamy judgment that the right to privacy is being upheld in in the court of law. That is an important asterisk and terms and conditions to be mentioned in the court of law. We have seen in the case of Jatendra Pal Singh and Vineet Kumar, Jatendra Pal Singh versus CBI and Vineet Kumar versus CBI. One happened, Vineet Kumar happened in the Bombay High Court, while Jatendra Pal Singh happened in the Delhi High Court. So in these both the cases, the CBI had collected evidence for a certain prosecution case and illegal evidence, which did not pass the second restriction, which is there must not be any less restrictive but equally effective alternative. The court said that there was a less restrictive means of going ahead with it, and the CBI did not do it. I'll explain the reasons why the CBI did not do it later on as well. And hence, in both the cases with Jatendra Pal Singh and Vineet Kumar, the case innately was dismissed, even though the person was considered to be guilty if you took into consideration the illegal evidence, which was obtained from illegal surveillance. So that is the nature of admissibility of the illegal evidence point. Then we come to understanding of the government on public policy, especially what are the panels which have been set up by the government to deliberate about the nature of surveillance in context with the right to privacy. We had the Justice AP Shah group of experts in 2012, which looked more into the nature of data and, for example, the corporate and then the more information technology aspect. But it also commented on the nature of privacy. Then also we had the Justice B.N. Shri Krishna Committee in 2017. So an interesting thing about both these committees was they took into consideration foreign best practices which have happened in India, which I will discuss the nature of why foreign best practices I personally believe should not be taken into consideration. But most of them commented on the nature of privacy. For example, I talked about game principles. For example, the person should be informed about it. It is more of so when it comes to like privacy, Estonia is considered to be the best model because if the government is doing surveillance under the Estonian law, the government has to inform you that you are under surveillance. So the best practices were taken from, I think, the Estonian law. Then the American law was also taken into consideration. But with, for example, Americans Patriot Act and FISA Act and others, the American model cannot be considered as the best practices model. Then we had the Justice B.N. Sri Krishna Committee, which talked about right to privacy as well. It was open to commentary. But the recommendations of both the committees were, sincerely speaking, I don't think taken into consideration while the DDP Digital Data Protection Act was made. But I do think few aspects were taken into consideration, but not the whole recommendations, especially the report of Justice AP Shah group of experts. Justice AP Shah's group of experts was taken into consideration while making DDP, but not the privacy aspect. So when it comes to the concluding remarks, I'll simply say this: the importance of privacy and the problems with unchecked surveillance. So when it comes to understanding the importance of privacy is inherently very important for every person, as it has been mentioned by Locke, life, liberty, and property. And as I mentioned previously, that when it comes to privacy in other countries' jurisprudence arises from other countries, as in the other parts of the Anglosphere. Nearly all countries from the Anglosphere and even France arises from the concept of right to property. But in India, it arises from the right to life. So privacy is, for example, you can do what you want without the government or corporates looking into it. After understanding the nature of the statutes, the agreements, and the Supreme Court judgments on it, I have personally come to the finding at the end of the research paper that the nature of privacy does exist when it comes to corporate surveillance. But when it comes to government surveillance, which is the usual suspect, if you can say, of the question of surveillance, when it comes, it's not that much there. I will explain it. I'll explain it in further detail in the next point, which is pre-trial pervasive nature of surveillance. As I mentioned about unchecked surveillance, while we do have the 3 tiers test, which I had mentioned about the Puttaswamy judgment, but the issue arises that the Puttaswamy judgment will only kick in The restrictions of Puttaswamy will only kick in when the thing actually goes to the when the thing goes to prosecution. In certain cases, when surveillance happens and there is no court case filed, the government can just get away with it. Not get away with it, but the government is permitted for the person to not be informed about it. That is the nature of surveillance which arises if the said case does not go into prosecution. But in most cases, when surveillance is done, it is either done for either the National Security Act, or it is usually either nowadays done under UAPA, or at times it is done for the Narcotics Act. It is accepted, and there are only chances that the pre-trial that the certain prosecution will not go into prosecution uh, will not go into a case. But in cases where it does not go into the court of law, the government gets a free hand from the Puttaswamy's three-tier judgment, from the three-tier test. And lastly, coming to the Indian context or legal decoloniality question mark, it is the, for example, when one goes through the understanding of the privacy which has been discussed by various eminent experts. For example, we have the Center for Open Democracy and other think tanks. For example, I mentioned in detail about their findings about the right to privacy, which they have mentioned. The nature is, whenever we discuss the right to privacy does not exist. I personally believe does not exist in a bubble. There are various aspects which are around it, and the moment we give absolute right to privacy, the compounding effects, the secondary effects, and the tertiary effects have to be taken into consideration. For example, one of the important things which we have to consider are these three factors: is history of societal violence, social strife, armed insurgencies, and terror across the modern history of the republic. The second is the over dependence of police and surveillance, and the number three is a lack of public awareness. So the important of the three are the first two. If you look at the history of social strife which happens in India, especially the armed insurgencies which we are seeing, uh, surveillance is an important mechanism by which the government can clamp down on these things, and it has been used. For example, in the especially if we have gone through the agencies which are allowed to do surveillance, you would have recognized that the Ministry of Defense, for the case of Assam and Northeast, and along with in Kashmir, is allowed to do. So it is an important part of counterinsurgency. So when it comes to surveillance, especially, and right to privacy will be an impediment when it comes to counterinsurgencies and preventing social disharmony, which might be social violence, social strife, and other things. A good example is, for example, recently we had the Haldwani. We had a major social strife. I'm not going to comment on that, but in Haldwani, there were through government surveillance, there were reminders that a certain thing by which might happen. So this is the importance of surveillance as well. If you give absolute right to privacy, the government response to prevent such things from happening, from certain communal violences, from social disharmony from spreading, also reduces. Then also the question comes is the over dependence. This point gets abetted with the second point, which is the over dependence of the police on surveillance. In India, when it comes to prosecution of crimes, it has been mentioned, I think, by the Hindu and in article and call as a newspaper when it works on fundamental rights is Article 14 of 2008. That's the website. They have stated, as per an RTI, the government is overly dependent on surveillance for prosecution of cases. So if you give right to privacy, many of the proper prosecutions or prosecutions in the court of law will stop to happen unless there is a balancing act between the right to privacy and the nature of surveillance state. And this is also where one of the things comes, that if you just do right to privacy without doing police reforms, then it would be unfortunate, because the nature is the police is today over dependent on surveillance because of the systematic underfunding of the police which happens, and the government, rather than and all governments since the foundation of the republic have more worked on the ground of proper rather than giving proper training to the police cadres. There has been more on the system of lathi charge and everything. There is an important requirement to have right to privacy, to have police reforms first, and then right to privacy has to be done up. But at the same time, right to privacy is important. And certain cases, for example, the Radia tape scandal, and for example, the Pegasus scandal, which happened, there has to be also systematic restrictions which have to be made public as well in certain cases to prevent the government to use surveillance in an unchecked manner, either for partisan effects or for personal gains, as we especially saw in Radia tape scandal, where personal tapes and personal life of the people were leaked by the government, but were leaked by certain sources and certain parties related to the government for unknown reasons. Honestly, the Radia tapes case was also popular for the surveillance, and because of the Radia tape scandal, the SOP came about for the interception policy and to ensure privacy. But the thing was, the government talked about how it is an important step towards open government. But the thing is, the policy which it's said that was seeking to push for open government was never made open to the public itself. That's an interesting thing. And the last point that I would like to mention is when it comes to right to privacy and nature of surveillance, in India, the nature of awareness when it comes to right to privacy and when it comes to the nature of government surveillance, both of them is slightly not looked into, and there is a lack of awareness about both, especially after the geo revolution and the cheap cost of internet in the Indian life. I think it is more important for civil society also to take up the mantle and seek to have a promotion of the right to privacy. There have been campaigns which are happening. For example, if you go through the internet, there are a few campaigns which are happening to promote right to privacy and surveillance, but this needs to be done at a greater stage. With this, my presentation comes to an end. Thank you, everyone. Thank you to all the mentors, especially Srinivasan sir and Partho sir, and a special thanks to Yashodhan and Avni for helping me with the presentation. I'm done.
Thank you for such an excellent presentation, Arghish. Your findings have added value to the knowledge of the non-legal professionals, especially young interns like me, who have very little to no understanding of the legal matters related to surveillance and privacy. We will now have the platform open for a question and answer session. I request the members to post their questions in the chat box. I'll read them out for Arghish, or else you guys can raise your hands and unmute your mic to ask the questions.
Not only questions, your comments are also welcome.
Yes, sir, definitely.
Yes, sir. Yashodhan has raised his hand.
Yes, sir, I have a question. If you permit, may I ask it to Arghish?
Yeah. Yeah.
Arghish, you talked about the Estonian model of surveillance, where the government has to inform the person which is under surveillance. But don't you think the very reason for surveillance is lost if the government informs the person? And if and ever such a model is implemented in India, will it work?
Yeah. So this is where one of the reasons I mentioned about it's a very funnily worded. I worded as legal decoloniality. Is because one of the reasons why I criticized the findings of the AP Shah Committee report and other NGOs which have worked on this is because they seek to import the Estonian model and the American model while completely not considering the Indian reality. For example, the nature of social strife that we have, the over dependence of the police. So I've actually commented against the right to against such models to be taken into India without due consideration. And I completely agree with your point as well, that if the person is informed that surveillance is happening, then surveillance ka point thoda gaya. But I also believe at the same time that there should be certain measures to prevent the government from doing completely unchecked surveillance in cases where the said surveillance does not lead to prosecution. That is the crux of your that's the crux which I like to present when it comes to your question.
Thank you, Arghish.
I hope it answered your question.
Yes, sir. Thank you.
Okay, Arghish, I have a question.
Yes, sir.
You talked about the need for having a right to privacy. You mentioned Puttaswamy case, of course. Would you like to enlighten the people, others who may not be aware of what exactly the Puttaswamy case? In brief, just maybe two or three sentences.
Definitely, sir. So the Puttaswamy case uh, innately arose because of, for example, the government under the previous UPA government had introduced the Aadhaar card scheme. So Justice Puttaswamy, who was a retired judge, argued that such a scheme of the government would be would be a breach of privacy because the information which was collected by the Aadhaar was meant to be slightly public, was led to be made public. Your name, your date of birth, then your residency, your phone number was available to the government to a greater level. That was the argument which was presented by retired Justice Puttaswamy. The Supreme Court, in its judgment, it was a thorough judgment of, uh, of more than 100 pages, in which the judgment upheld the Aadhaar card, but at the same time, it continued the legacy of the PUCL judgment, which talked about the importance of right to privacy, but it went a step ahead. It agreed with Mr. Retired Justice Puttaswamy that privacy is very important, and they recognized uh, that privacy is very important, and they provided for the three-tier test. So that is why we consider Puttaswamy to be an important case. While the Aadhaar card was that legal, right to privacy was recognized. Have I answered your question, sir?
Yes, yes. Actually, I know about the case, but I just wanted you to explain it a little bit more so that others may also be privy to that particular information. So, because it was a very, very important judgment made by a nine
Yes,
bench judges judgment. That was what was very important. It went through a whole process, and before it reached that, you know, that nine bench being constituted, nine judge bench being constituted, and the judgment came in. Yeah, that's what I wanted others
yes,
also
sir.
to know. That's right. Thanks.
Yes, sir.
Thank you. Good.
Just to add, sir, my previous answer, it was recognized under Article 21, which is right to life and liberty. And an interesting thing is, while the three-tier test has been accepted, Justice Call in his judgment had mentioned a bit more thorough test and various grounds on which it could be done, but that was not the majority opinion on it. So the three-tier test is what we used today. I think so. We had a question. Does India need more legislation to adopt best practices in the world? If yes, what are the main areas you are looking into? Uh, so when it comes to need more legislations to adopt best practices, I personally believe the DDP Act, which is the Digital Data Protection Act, is quite enough when it comes to preventing corporate surveillance. But when it comes to, for example, the government surveillance, that is an interesting thing to think about. Telegraph Act has been recently amended, but it still retains the surveillance nature. Uh, I find that when it comes to best practices, we can perhaps go for the American model, where there is a nature of surveillance, but at the end of the day, you require for uh, a court to provide you, a judge is required to sanction the surveillance from happening. That is an interesting model that we can think about. But at the same time, sir, the question also arises is surveillance may we can legislate on targeted surveillance. Like I had discussed about mass surveillance in the Yamunotri itself has surveillance. Yamuna, you can amend the Yamuna, but if you don't discuss the Yamunotri, then it is the agreements which are signed with the technical service, telephonic service providers and the internet service providers. Even the agreements have to be made in such a way that unabated government collection of information, especially metadata. Like, for example, in a research paper, I've gone into detail, like, for example, your call records, then whom did you call, when did you call, how many times did you call. The government has access to everything here. So I personally believe, along with legislations, we also need to consider the agreements which have to be amended. I hope this answers your question. And when it comes to, sir, agreements, I am not aware of the best practices about the world. What I can personally say is we can look for amending it in an Indian context where such surveillance is allowed, but there are checks and balances. And greater checks and balances could also be constituted if you simply make the findings of the telephonic of the committee which is set up under what is now the Bharat, which is set up under the Telegraph Act, if you just make the findings of the committee public, for example, in certain cases where national security implications are not there, then in that cases, I think that can be a massive reform in its own way by simply having an open government policy. I hope this answers your question, sir.
Thank you.
Thank you, sir.
I have no questions to ask, but just a comment to make, not for Arghish, but in general, for us to appreciate this particular topic. What we perceive as national security is not written in stone. It is not concrete. Today, for example, what we see is in the nation's security interests. Tomorrow, due to a changed environment in which the country faces itself, may actually cease to be a issue as far as the country is concerned. But whether the environment changes or it actually becomes more complex, whether the national security interests, when we say national security, let's not think about our not so friendly neighbors alone. We have to look at inside also. We have insurgencies, we have communal issues, we have so many other forms of internal violence also taking place, which are essentially anti-government and affecting common people. Anti-government, but affecting common people. This kind of challenges to the, shall I use the term, integrity of the society, challenges to the integrity of the society or peaceful functioning of the society will continue to be present and will continue to become more manifest in different forms because of technology. The more technology, the more will be the means by which the elements who are interested in disturbing the peace and stability of the society also will work. To that extent, government being responsible for upholding peace and stability, law and order in the society, has to use certain means. When we say it has to use, we all understand, yes, it has to be used. But when we say it has to use, that is precisely where the problem comes, where we perceive that it is infringing on my privacy because I'm not an anti-national, but why should I? Voluntarily or otherwise, indirectly be monitored by someone. Okay. This dilemma, this dichotomy will continue to exist. It cannot be wished away or it cannot be changed. But what is to be noted from his talk also is that apart from those two committees, Justice Shah and Krishna committees, apart from those two committees, what stands out as a very credible framework, which obviously the Honorable Supreme Court of India has applied its mighty mind, I'll say 9 judges, the minds of 9 judges, and evolved at least 3 guidelines. In due course of time, when that environment which I talked about in the beginning begins to change more, these guidelines also will change. It is only a question of time when a new case props up and the court has a benchmark judgment and from which it will see what further. Because the Supreme Court's responsibility is not just one judgment or upholding a precedent. It has to see whether whatever is being done by the government is in consistency with the Constitution. If the Constitution says liberty, the word used in the preamble to the Constitution is liberty. But that liberty, after that liberty, the Constitution, the preamble also uses one more word, which is very important for us to understand. It says fraternity, which means promoting unity, which means social integrity of the society, which means peaceful coexistence, which means law and order. So, at some point of time, again, the Supreme Court has to look at. See, Puttaswamy judgment, we can say, is a very detailed deliberation on the concept of liberty enshrined in the Constitution. Whether it pertains to 14, 19, 21 is a matter of debate. But the origin is in that concept called liberty enshrined in the Constitution. But at some point of time, it is inevitable that this will be tested against the concept of fraternity. And that is the time when again new regulations have to come, new restrictions have to come, or new liberties have to be given. So this will continue to be dynamic, but as citizens, it is necessary for us to appreciate, at least for law-abiding citizens, I'm saying, that the government needs to do it. The intended purpose, we must consider it as honorable. We need not doubt. There will be problems. There are issues. That's why court cases come up. Okay. Like you take Maneka Gandhi's case, for example. Simple question of passport. Simple question of passport. But then the Supreme Court had to interpret it and read it along with Article 21. So at some point of time, again, it will get refined. And I am very sure that whatever happens will be in the interest of the larger society. We are not talking about a government. We are talking about society called India. I'm sure it will happen. So it's a nice presentation, Arghish. Okay, that's all I have to say.
Thank you, sir. Sir, on your point of the state function, so one of the first test which the government gives is the legitimate state aims, state goal, and further on, sir, it's very far-sighted that the Supreme Court recognized that privacy cannot infringe upon the existence of the state itself. As you have mentioned, it's a very interesting thing. The Supreme Court, in its far-sighted judgment, had recognized this. And sir, functioning of the state. Sir, I do agree. But one of the thing is, for example, sir, as you had mentioned about the integrity and sovereignty of the nation. So word to word, that is actually one of the grounds on which surveillance can be done in India, as per the DDP Act and the IT Act. And as for the DDP, you can also do it for the functioning of the state. Or it's a very interesting. So, but I personally believe that as you have mentioned, there needs to be a balancing act which has to be done, and it needs to strike a chord with the right to privacy as well. Right to privacy in the 21st century is going to be one of the most important battlefields when it comes to the arguments by the state and arguments by the civil societies.
Very true, very true. I fully agree with you. That's why I only mentioned two things. Like we are now so far talking about what the preamble says as liberty. But I said there will be a time when we will read it together with fraternity. But I haven't mentioned the third. I will mention the third also. Justice. That's also, a term in the preamble. If we read all the three of them together, see, justice is not about, courts giving judgments. Justice is social justice, political justice, economic justice. It is justice in all dimensions of the society. I mean, the life of the society. But when we start reading these three things together, when I say we start reading, I mean when the court starts reading these three things together, then this test also will change. The parameters which will be applied will change. The tools that will be permitted will change. They may become more, they may become less. Okay. So that's why I use the term dynamic. It's a very dynamic thing because this topic itself is very, very relevant. Okay. It affects everyone, whether you know it or you don't know it. It affects you. It affects every citizen. Therefore, it's a very interesting topic. All of us must be aware. Yeah. Okay. Good. Thank you. Yashodhan, you can continue.
Thank you for sharing your insights, sir. We'll now move on to the next session. I request Commander Nair, sir, to deliver his note about the DRAS research writing program. Over to you, sir.
Am I audible?
Yes, sir.
This is indeed a very relevant topic, and Mr. Arghish has done a wonderful job on this topic. The way he presented indicates the depth of knowledge he has on the latest stuff connecting to this topic. Privacy of citizens' data cannot be compromised by any government, but sometimes national security becomes a priority. There exists a thin line between them, and we need to address this issue on a case-to-case basis. There are software-based security systems currently available to safeguard the privacy of the personal data, as well as tools available to government to check the data of a private citizen. Policy compliance by data hosting platforms, intermediaries are never rational across the nation. We have seen it many times. Many platforms are pro-users and anti-government. Current government is doing its best to settle this conflict by proper legislation. I hope that they will opt for the best practices in the world. Let me appreciate the mentors, Dua sir, Pathasali sir, Srinivasan sir, in making Arghish select this challenging topic for research. After a good presentation, the bar is getting raised, sir. Let me wish Arghish the very best. Thank you very much. God bless you.
Thank you, sir.
Thank you, sir. I now invite Commander Dr. Ashok Dua, sir, and Group Captain Parthasarthi, sir, to share their perspective on the topic.
I would like to comment on Arghish Akolkar's presentation this evening. Very well presented. My hearty congratulations to you. And the delivery was very confident. I liked it. As far as slides are concerned, I think you will have to take into consideration some of the slides that you presented. The screen being, computer screen being very small. So those fonts are not really visible and one can't, understand what is being said. So maybe for the presenters in future, this point may be taken into consideration while presenting. See that whether your slide is visible or not. Otherwise, it loses its meaning. Having said that, I would like to say that Arghish Akolkar's presentation on government surveillance against the right to privacy in matters of cyberspace in India was very well presented. And it's a topic which has no boundaries, as Dr. Srinivasan said, that it's a dynamic topic. It will continue to change. New situations will bring in new legislations and so on and so forth. So having said that, again, hearty congratulations. And I'm happy that I could listen to Arghish on this topical topic. Thank you.
Thank you, sir, for the kind words.
Thank you, sir.
All right. Taking on further with the views that the mentors have got. I would like to say right at the onset, wonderful presentation that is so evident from the way you answered the questions or the queries that are raised, shows that Arghish has got an in-depth knowledge on the subject and he really prepared well for the whole presentation. Just adding on to what Commander Dua has said about his presentation style per se. Knowledge-wise, no doubt there is absolute command over that particular topic. But the presentation-wise, I would like to say that you would like to put all the points in terms of bullet forms. There was no doubt about your command over the subject. You could speak very fluently. So my suggestion is in future for you and for others, just put the short bullet form on the slide and you continue speaking. That will be much more better for the people to understand. The next thing I would like to point out was your speed of delivery. Though fluency was not in doubt at all, but I think you were a little too fast. So novices like me or any other person would find it a little difficult to follow the thread of your presentation. So if you can just cut down on the speed. I know you wanted to cover everything up in that time that is given. Of course, you did overshoot. You spoke for almost for about 48 minutes. Not to point out that, but I'm sure that you were trying to cover everything possible. So that's why the speed was fast, or maybe it's a natural style. But when it comes to presenting a particular topic, I would suggest that you monitor the speed of delivery so that is much more clearer, much more specific to the people. All in all, a very well bought out, topic wherein showed very clear kind of a compromise. I'll not say compromise, for want of a better word, I'll say compromise between the right to privacy and the need for surveillance. Okay, you brought it out very well. Okay, and you brought it out how it can be, taken further up. Definitely, it's an evolving subject, very relevant subject in today's world. But you did an excellent job in the whole thing. Congratulations once again.
Thank you, sir. Thank you, sir, and Ashok Dua, sir. Sir, sir, I had to cover quite a lot, so I was a bit in. I'm very sorry for that. And I made a mistake regarding the slides, sir. I'll keep that in mind.
Yeah, we understand. We
Connection.
understand your issue, but all in all, a wonderful presentation. That's what I say. Minor point. All
Thanks.
this will come with practice and over the period of next few years. I'm very sure you will become a much better orator, should I say? Yeah, a much better person in terms of giving presentations. I'm very sure about that.
Thank you for the kindness.
Thank you, Commander Dua sir and Group Captain Parthasarthi sir, for sharing your insights. Now, as we conclude this program, I call upon Avni to deliver the vote of thanks. Over to you, Avni.
Thank you, Yashodhan. Ladies and gentlemen, and our esteemed mentors, I would like to extend my heartfelt gratitude to each one of you for being a part of this insightful research presentation. And a special acknowledgement to our mentors, Dr. Srinivasan sir, Commander Dr. Ashok Dua sir, Group Captain Parthasarthi sir, and Commander J.K. Naik sir for their guidance and support. Mentors, your presence has added immense value to the occasion, and we appreciate your engagement and enthusiasm. Thank you for your efforts to provide us interns with an environment that is conducive to celebrate the spirit of discovery and innovation in the realm of research. I would also like to express a sincere thanks to Arghish for sharing his research findings and contributing to the intellectual growth of the community. Let us contribute to foster a culture of knowledge sharing and collaboration. Thank you to everyone once again for your participation and support. Sir, you're muted.
Yeah, that's good. Take a good conclusion, Arnie. And Yashodhan, you did a good job hosting us today. And we are so happy that Duasar is on screen. Yes.
Thank you, sir.
It's always a pleasure to be with the interns here on this platform, because it's a platform where you learn. And I am a learner, and it's a pleasure being here with you all. Thank you so much.